All rise. Here in the name of Morahan and HM Assistant Coroner from West London and others.
Yes, now,
Please, Your Lordship.
Mr. Bowen.
Yes, my Lord.
Good morning, is all I was saying, really.
Good morning. Thank you. Well, my Lords, thank you for allowing us to, for me to appear in this, well, perhaps not as unorthodox as it once might have been, way. But I am fit and well enough to appear today, and I hope the technology works. My Lords, can I just deal with a couple of housekeeping matters before I dive in? Can I just ask, did my Lords receive a document called List of Essential Reading and Housekeeping a few days ago? In which case I can cut short some of my housekeeping. And there's, in addition to the papers that are referred to there, a supplemental bundle of authorities. Can I just ask if that was received?
Yeah.
Yes, thank you.
Yellow.
Yes, a yellow
Thank you,
one.
my Lord. My Lord, I'm sorry not to introduce my land friend Mr. Hoff, who appears for the respondent. My Lord, can I ask permission for those instructing me to have their telephones on so they can send me electronic post-its during the course of the hearing?
Yes, of course.
Thank you. And my Lords, would it be appropriate to break for 5 or 10 minutes just before 12 to give the shorthand writer a break, or would you like me to press straight on?
I think we can press straight on, unless
Thank you, my Lord.
I'm told to the contrary, but it wouldn't be normal to stop. But Mr. Byrne, I appreciate that you're under the cosh a little bit. You say you're feeling fine. If you're at any time in need of a short break, if you're not feeling too good, just say, and we'll accommodate you, I'm sure.
That's very kind of you, my Lord. Well, with my lady's leave, I propose to address matters in the following way. I'm going to shortly identify the issues for determination. Secondly, make 2 short points as to the significance of the issues raised. Thirdly, to address my Lords on a few relevant points in relation to the background facts. Fourth, to sketch out the appropriate legal framework. Then fifth, to develop some propositions of law in relation to the first 3 issues, which largely follow the skeleton argument that my Lords have. Then sixth, to develop the grounds of appeal, which again will be very much in accordance with the skeleton. And then last, to deal with the 4th issue, which is the fresh evidence issue. But I understand there's no objection to my Lords considering Dr. Langford's report to bene esse and ruling on its admissibility when you rule on the judgment, when you give your judgment generally.
Yes. And then just on your
Lords,
just Mr. Byrne, on your skeleton.
yes.
It's perhaps more accurately described not as a skeleton, but as a fairly full written argument. It's a little longer than normal. I take no point about its length, but we have read it, and you will appreciate that we're relatively familiar with the authorities, not least because at first instance Lord Justice Popplewell set out the relevant parts of the authorities and analysed them in some detail, and members of this court have, as you know, been round this course once or twice before.
Well, my Lord, of course, I'm aware certainly that my Lord and my Lady have very recently dealt with these issues. So I will do my best to skate over those matters which I can, and to only dive into those matters where it's particularly crucial to the argument.
Good.
But my Lords, the 3 issues are straightforward in the sense that in their articulation, if not the answer to them. First is whether there's an operational duty in principle in circumstances such as these, where a person like Tanya Morahan, who's a voluntary psychiatric patient, while away from the hospital, dies from a self-administered drugs overdose. And my lords, the question of whether she was absent without leave at the time of her death may or may not be relevant to that question. The second question is, the answer to the first question is no, then we accept the appeal will fail. But if the answer to the first question is yes, then is there an automatic duty of enhanced investigation requiring the coroner to conduct a Middleton type section 5.2 inquest? And if the answer to that is yes, then the appeal will succeed. Only if the answer is no, do you turn on to the third issue, which is if was there.
Oh. We'll just have to pause. Mr. Bowen's link has frozen. I hope it's not a consequence of anything at our end. It is one of the hazards, I'm afraid. Do we have a telephone contact number for Mr. Bowen? His solicitor's tweeting or contacting him. Could you tell him he's frozen, and he may need to check his link. He's back. Mr. Bowen.
Can you hear me all right? I've just had a message saying that I'd frozen.
You had frozen. I don't know. It may well be that your Wi-Fi is not perfect, but you're back with us now. So let's hope we're okay. You had told us.
Very good Wi-Fi, my lord.
Good. You were saying that if the answer to the first question was yes, then there's an automatic enhanced investigative duty, and I think that's as far as you had got before you froze.
Yes, sorry, my lord. So if the answer to the first issue, whether there's an operational duty, if the answer is no, then we accept the appeal fails. If the answer is yes, then second question, is there an automatic duty of investigation? If there is, the appeal succeeds. But if there isn't an automatic duty, only then do you get on to whether there's an arguable breach on the facts. But if there is, then again, there is an enhanced investigative duty. The practical significance of the issues I was just outlining, although I may have frozen at this point, I'll go to the scope of the inquiry carried out by the coroner, although we accept in this case the scope that the coroner has indicated is appropriate would be the same whether Article 2 is engaged or not. Yes. Secondly, the scope of the determination made by the jury, because the jury must consider not only the first questions in Section 5.1 of the Coroner's Justice Act, but also the second question of in what circumstances the death occurred, which allows for wider narrative conclusions. And my lord, the question of legal aid, which is always very live in these circumstances, and it's touched on by...
it's the tail. Forgive me, it's the tail wagging the dog, and it's
yes, my lord.
It's not a factor that the decision maker can take into account, is it? I mean, it's most unfortunate that we've now had is it 3 pre-inquest reviews, or 2 or 3 pre-inquest reviews to determine this question, 2 days in the divisional court, possibly 2 days here, and this is really all about whether there should be legal aid at an inquest, which has now been delayed by probably 3 years. I mean, this seems to me to become rather a monster that is consuming the whole inquisitorial process of the coroner's court. An observation I think I made, not in quite those terms, in Maguire. So this really is about legal aid, isn't it?
Though, my lord, you will have. You mentioned this. You commented on this in Maguire when you referred to the intense, hard-fought debate that often occurs in these cases, which is indeed very much linked to the question of the availability of legal aid, but not just to the availability of legal aid, as I've said. It goes beyond that. The reason why legal aid is significant is that if it's an enhanced investigation, then Article 2 requires that the family be properly involved in the process, and that is a component of Article 2. And the Court of Appeal in Cairn, which was endorsed by the Court of Appeal in Humberston, made clear that in order for the family to be properly represented, to be properly engaged in the investigation for Article 2 purposes, they needed to have legal aid, and that's why legal aid is necessary. It's actually a component of Article 2. And I'll just give my lord the reference. It's Humberston, paragraph 24, and that's volume 1, tab 18 at page 451. And one of the reasons, my lord, we submit one of the practical consequences of your finding that an automatic duty is owed in a case like this is that those hard-fought debates don't need to happen, because as Lord Hope pointed out in Smith, at paragraph 98, where there's an automatic duty, it has the benefit of clarity. Everybody knows where they stand from the outset. Legal aid available from the outset. And there won't need to be 2 days in the coroner's court, 2 days in the divisional court, and 2 days in the Court of Appeal. So, my lord, those are the points in relation to the practical significance. As far as the wider general public interest, first one is that this is the first time where there's been consideration of whether a Rayburn type operational duty arises in relation to risks other than suicide. So it's of some wider importance for that reason. The second is it's the first case that's looked at whether an automatic duty arises in circumstances such as these. And there is a conflict between the divisional court's judgment and that of Mr. Justice Green, as he then was in the case of Letts, which this court will need to resolve. And the third is what is the proper approach that a coroner should take in cases such as these, in particular in relation to findings of fact to the test of arguability. My lords, can I turn then to the factual background? And my lords, it may help if you have opened the judgment where the Court of Appeal sets out the background narrative, and there's very little I want to add. So, but if we pick it up at paragraphs 6 to 8, one will see the extensive history of mental health and substance misuse that featured in Tanya Morahan's unfortunate circumstances.
Well, Mr. Byrne, we've
but one point that,
forgive me, we've obviously read this, and also the description of the facts in your skeleton argument. So I think you can take this quite lightly.
Thank you, my lord. The only point I wanted to pick up about at this point is in relation to the admission on the 3rd of December 2017, because my lords will see later in the judgment the divisional court found that there was no history of accidental overdose in Tanya's case. That's at paragraph 124 at page 106 of the core bundle. But in fact, when she was admitted to hospital on the 3rd of December 2017, she was taken to A&E and had to receive emergency treatment. And you'll see that if you've got the supplementary bundle to hand, you'll see the notes from her admission to the A&E department on page 3, at the bottom of that page. And you'll see that it reads 3rd of December 2017 at about 2:30. It says urine dip is showing positive for cocaine and opioids. And then
Sorry,
Tanya's heart rate is coming down. It was 120.
I'm sorry, Mr. Bowen.
Sorry,
I appreciate it's really difficult doing it through a link, but I think we need the page number again in the supplementary bundle, if you'd be so kind.
It's page 3.
241, I think, at the bottom. I think.
Page 3 of the bundle, the supplementary bundle.
S3 at the top.
And it's the entry at the bottom of the page.
Thank you.
So my lord have that.
Yes.
And you'll see that the the author wrote, Tanya's heart rate is coming down. It was 120, is now 105 after half a bag of fluids. The increased heart rate may be a result of the cocaine, but Tanya is unable to say when she took cocaine. A&E will continue to push IV fluids, and this will bring the heart rate down. Joe will contact me once Tanya is medically cleared. Heart rate needs to be below 100 to be medically clear. Once clear, I will review, as Tanya may require a mental health act assessment. So, my lord, the drugs on that occasion, of course, that was the day she was admitted and was then subsequently detained until her discharge on the 25th of June, was characterised by an overdose of some kind. So, my lords, we can turn to the discharge decision on the 25th of June. Now, it's clear, and I made this clear in the divisional court, we don't seek to demonstrate before this court that the decision to discharge on the 25th of June was itself a breach of Article 2. What we say is that the steps that were taken afterwards amounted to a breach of Article 2, but it's important, my lords, to see what decision was made on the 25th of June. And you have in the same bundle, the supplementary bundle, a copy of the multidisciplinary team notes, which start at page 54 of that bundle. I won't take you through it, but when you read it, it will demonstrate the following matters. The first is that Tanya has a habit of playing down her mental illness and her substance misuse. That her home was in no fit state for habitation. That the removal of her son into foster care had caused her serious distress, and that she was in the process of trying to appeal the adoption at the time of her discharge. She was in an abusive and exploitative relationship with Caleb's father, who had a forensic history and was himself a drug user. She had a lack of community support. Her mother had died, and it was not known if Tanya had any other friends. And the care coordinator pointed out during the course of the multidisciplinary team meeting that Tanya had rarely managed long in the community. She didn't make it to 7 days follow-up before readmission on the last occasion, and it was always substance misuse as a factor in readmission. So those facts were all known at the time. But could I ask you to turn to page 59, which shows the outcome of the decision? And there are 2 points I just want to emphasise, which didn't receive as much emphasis in the divisional court judgment. The first is at the top of the page. Actions to be taken if AWOL. And it says leave suspended. Now, my lord, we know that that's not what happened when she did go AWOL, but that was the decision that was taken on the 25th of June. And then just below that, under plan from ward round, you'll see in the left-hand column under action, the fourth item down, says Tanya agrees to only return home with OT accompanying her for now. So it wasn't anticipated that Tanya would be going home on her own at this stage. And all I would observe is that there's nothing in the notes to demonstrate that there was a reappraisal of that before, in fact, she did go home and then went AWOL. My lord, the other point to point out is that she was discharged effectively on condition that she remained as a voluntary patient. And when you read Dr. Rahim's statement, paragraph 49 of her statement, which is at supplementary bundle page 115, it makes clear that it was because Tanya agreed to remain as a voluntary patient that the team felt able to discharge her. And although we've not had an opportunity to ask Dr. Rahim the question, one of the questions that would be asked is that if Tanya had not agreed to go to remain as a voluntary patient, as a voluntary inpatient, would she have been discharged? To which the answer inevitably we submit would have been no. And my lords, the last point to make at this stage,
again, forgive me.
The decision was made.
I'm sorry, Mr. Bowen. I just want to find the precise sentence that you were reading. We're on page S115.
Page 59. Yes, page S115.
Which paragraph?
It's paragraph 49.
Okay.
If you look at 3 lines from the bottom, she told us that she was willing to remain on the ward as an informal patient to continue to attend therapy groups, to engage with psychology and drug services, and to take her medication. The team considered the chronology of her illness, her good progress in compliance with the treatment plan. She did not fulfill criteria for detention, was asymptomatic with good insight, and had the capacity to continue with her admission and treatment on a voluntary basis. Now, my lords,
Well, hang on,
we've not had an
wait a
opportunity
minute.
to ask Dr. Rahim the question.
No, forgive me, Mr. Byrne. You just told us that Dr. Rahim was saying that had she not agreed to remain as a voluntary patient, she wouldn't have been discharged. But I'm sorry, I just don't see that comes from those sentences that we've just read.
What the submission I made was this: were Dr. Rahim to be asked the question,
Yes.
would you have released Tanya from the section if she had refused to remain as a voluntary patient and had said, I'm going to leave immediately?
Yeah.
Would you have released her from the section?
Yes.
To which the answer must be no, not least because when she went AWOL, my lord, on the 5th of July, Dr. Rahim wrote to the team saying that they needed to consider resectioning her.
Yes. Well, you can ask him.
I'll show my lord that.
He can be asked that question at the inquest.
My lord, yes, of course you can be asked that question at the inquest, but at the moment what we're looking at is the circumstances that were known at the time of
Yes.
the discharge, and whether they were such that when one comes to the arguable breach question, which is question 3, these were factors that are relevant to the questions that the court needs to consider. And we say that Tanya was only released on condition that she remain as a voluntary patient. And I've just showed you in the monthly disciplinary team meetings minutes that it was made clear on the face of those minutes that if she went AWOL, then her leave would be rescinded, would be revoked. And also that she was only permitted at that stage to go home when accompanied by a staff member. Well, the only other matter, just to point out at this stage, is that there's nothing in those minutes or in the running notes that demonstrate that there had been any care planning for Tanya's leave. That's to say, care planning for purposes of section 117. And I'll come back to that. It's one of the points made before the divisional court, who said, well, the duty to provide care doesn't arise until after somebody's actually released from hospital, which is correct. But the care planning process is something that is required to happen earlier in the process. And when I take you to the case of Raybone, I'll show you how in Raybone, Lady Hale considered the absence of adequate care planning to be one of the factors that showed that there was a breach of Article 2 in that case. I'll just give it to you now. If you'll note, it's paragraph 107 of Raybone, volume 2, tab 37, page 1001. So, my lord, then, in terms of the first AWOL, this is the point at which we say that there were failings by the trust, which amounted to arguable breaches of Article 2. And in a nutshell, what we say is that following the first AWOL, which was between the 30th of June and the 1st of July, when Tanya absconded to Germany, rang the unit from Munich to say that she was drunk. Although she did return voluntarily the next day, it's our case that at that point, the multidisciplinary team arguably should have taken steps either to revoke her leave or to have resectioned her or to have taken some other steps that would have provided greater protection for her in the event that the same thing happened again, which it duly did 3 days later. And my lords, I'm not going to take you through it in detail, but you'll see the chronology that led to the first AWOL in the running notes, which run in a reverse chronological order in the supplementary bundle. And if you pick them up at page 52, that's the time. That's when the section was rescinded, I just want to show you a couple of items. The first one is on page 50. And you'll see about 2/3 of the way down, there's a note entered on the 28th of June 2018 by Laura Hayward, registered mental nurse, at 1:15. And this was a note that was made after the occupational therapist had gone back to Tanya's home with her. And then about 5 lines down in the body of the notes, it reads, I advised her that her flat wasn't habitable at the moment, but that she could work with the OT, the occupational therapist, towards getting it clean and sorted. Then she would be allowed leave to go and spend time at home. So in other words, it's quite clear that at this point, it's considered that A, Tanya is essentially only being allowed out of the hospital if the hospital let her do so. And secondly, one of the conditions which I drew to your attention on the 25th of June, that she couldn't go home without being accompanied by the OT, was being reinforced on the 28th of June. And you don't get any entry in the notes thereafter of there having been a reconsideration of that condition. And if that was indeed a condition that was placed upon her movements on the 25th of June, then one would expect that the medical team would have had good reasons for it and would then have had good reasons to remove it thereafter. And then you'll see from those notes on page 49, the previous page, after she went AWOL for the first occasion, and that is top of the page. Tanya was off the unit the second entry on that page. Tanya was off the unit upon commencement of the shift. According to the handover, she returned to the unit at 3:30 to collect something from her studio flat, and then went out again. Staff contacted her numerous times on her mobile phone with no answer. And despite her informal status and current risk factor is low, staff circulated her to the police for a welfare check. So this is the first AWOL, and then at the top of the page, top 2 lines, it was reported by night staff that Tanya had rang at 7 a.m. to report she was in Munich. She said she was drunk and leaving for Germany. It was a stupid thing to do. And she did indeed return the next day. And on the 2nd of July, she was reviewed by Dr. Head, one of the psychiatrists. And if I could ask you to go to page 47, my lords, and you'll see the last entry on that page is the review by Dr. Head following her return from Germany at the weekend. Now, my lords can read that under at the bottom of the page. It says impression, no new physical or mental health concerns. But there's no record in the notes of there having been any discussion amongst the multidisciplinary team at this point as to whether Tanya's leave should be revoked, as it said on her multidisciplinary team minutes on the 20th of June. What you do have is in the same bundle, you have what Dr. said, the 1.5 of that bundle.
Could you give us the page again, Mr. Bowen? The link was a bit wonky then. The page number?
Yeah, my lord. In fact, 116, paragraph 51.
It was 116.
Dr. Rahim, she was the responsible clinician. She reports, paragraph 51, Tanya's failure to return, and then about 2/3 of the way down that paragraph begins near the end of the line, the following morning. It says the following morning she was seen by the ward doctor. I've just shown you the entry in the running notes that show that. She said she travelled to see friends in Munich. She was found to be euthymic in mood, with no deterioration in mental state or physical health. she agreed to work closely with staff around her leave. The team considered this was the first time during her rehab admission that she had failed to comply with her treatment plan. She had remained stable in the mental state. She appeared remorseful regarding the absconsion and was willing to continue her treatment. Therefore, it was found that there were no grounds for use of the Mental Health Act. Now, my lord, there is nothing in the medical notes that show that there was a team meeting on the 2nd of July. All you have is the bare entry by Dr. Head. And given that that Tanya had done two things that were clearly impulsive. Firstly, she'd gone AWOL, travelled to Germany. Secondly, she'd got drunk, and that was the first time in 6 months she'd taken alcohol, because she'd been having regular drug and alcohol tests that had come back negative. That was an extraordinarily strong indicator that her impulsive behaviour was such that they needed to reconsider the position. Now, the divisional court simply accepted at face value what is said in Dr. Rahim's statement. It's our case, among other things, that for the purposes of establishing an arguable breach anyway, the divisional court took the wrong approach in essentially making a finding of that kind. But the point is that at that stage, we respectfully submit there should have been serious consideration of Tanya's welfare and whether, indeed, in accordance with the agreement on the 25th of June, her leave should have been revoked. And my lord, you'll see that on the same day, if you go back to page 47, I've just shown you the entry when Dr. Head carried out the review. There was a risk assessment that was carried out by the registered mental health nurse. In fact, two things you can see just above Dr. Head's entry on page 47. The first is that a UDS was done. The previous, in the middle of the page, my lords, at 1322. That's a urine drug screen, and she was negative for cannabis. What we haven't been able to establish is whether that screen would have picked up any other drugs, including cocaine or opiates.
Mr. Bowen.
Above that, you can see. Yes,
Mr. Bowen, can you just pinpoint you say you criticise the divisional court for its finding about this incident. Where precisely are you referring to in the judgment?
Paragraph 20 and paragraph 131. So paragraph 20 is at page 71 of the bundle.
Yeah.
Because you'll see at paragraph 19, the divisional court set out Dr. Rahim's evidence that I've just shown you on page 115. Sets out verbatim her evidence in her statement. And I made the point before the divisional court that that reasoning can't be found in the records. That's to say there was no record of any multidisciplinary team meeting. But the divisional court held that the evidential basis for it was. And then if you go to paragraph 131.
Well, just again, pausing there, it's in paragraph 21 that the divisional court, or Lord Justice Popplewell, refers to the notes. You're not suggesting, are you, that that's inaccurate in the sense that that's what the notes said, but you are submitting that the conclusion is not sustainable. Is that how it works?
We respectfully submit that there is no document in the notes. There's no point in the notes either that records essentially the decision that Dr. Rahim refers to at page 115, which is set out in paragraph 19. But nor is there any document that shows that they considered what the range of options might be, short of revoking her leave or resectioning her. For example, putting in place more community support. And there's certainly no consideration anywhere the question of if she did relapse and start taking drugs again, like she'd started taking alcohol again, whether that would create an enhanced risk due to the fact that she'd been absent for 6 to those drugs.
Mr. Bowen, if one looks at the notes at S47, we can see the note
Yes.
by the registered mental nurse, which is at 1632, and she has at that point updated Tanya's risk assessment. It says,
I was just about to take my lady to that.
Well, thank you, but would you be so kind, please, just to clarify this? Have informed CCO.
Yes.
What is CCO?
That's the community care coordinator. So that's the social worker who's attached to the team, Yvonne Scott. So she's the community social worker.
So on that day, within a space of, it would appear, 4 hours, she is seen by a doctor, she's seen by the registered mental nurse, and the registered mental nurse is in communication with the community care.
I don't doubt that, my lady. I accept that.
Thank you.
And I was just going to show you the product of the risk assessment that was carried out. And my lady, you'll find that my lord, you'll find that at page 60 of the same bundle. It turned to page under the that were considered. Is she at harm to self through neglect? Yes. Is she at high risk posed to this person through substance misuse? The answer was yes. And then if you get to point 14 at the bottom of the page, she's recently been discharged from Section 3, has a vulnerability to taking illicit substances and misusing alcohol, which leads to deterioration in her mental health. Over the page, paragraph 22, Tanya has a history of substance misuse, which has had a detrimental effect on her mental health. And my lords, the point that we make is that this was a significant development, the fact that she'd gone AWOL on the 29th of June and 1st of July, and she'd taken alcohol for the first time in 6 months. And at that point, there should have been a reconsideration. Now, we can see there was a review by Dr. Head, and we can see there was a renewed risk assessment. And you've seen the evidence of Dr. Rahim, although there's no evidence for there having been a multidisciplinary team meeting where these matters were reviewed. But it's our case that it's arguable, taking into account the very low threshold, that at that stage the trust should either or reimpose the condition in return accompanied by a member of staff, or ensure that there was a proper discharge plan or leave plan in place in the event that she... I gather I've just broken up. Can you hear me, my lord?
Well, unfortunately, you seem to break up just when you're making the most important part of your submission. So,
right.
Could we just wind back about a minute? I think you were saying that it was
Yes.
arguable that they needed to do a number of different things, and I think it's important that. Whoops, are you there, Mr. Bowen? No. You're back.
I can hear you.
You disappeared altogether, I'm afraid, for a moment. Could you list the things that you say should have been at least arguably done? I think one was a care plan, but perhaps you could just start again with those.
The first was, the most draconian, I suppose, would have been that she would be readmitted under the Mental Health Act. And indeed, that is what the team considered after she went AWOL the second time.
Yes.
Secondly, they could have revoked her leave. Thirdly, they could have reimposed the condition on the 25th of June that she only leave when accompanied by a member of staff. Fourthly, they could and should have ensured that there was a proper leave care plan in place. And fifth, this was the point where acute and explicit consideration should have been given to the risks if she were to relapse and start taking drugs again, like she'd relapsed and started taking alcohol again. What would be the risks to her life? And it's at this point that there is absolutely no evidence that the trust were even aware of the risks associated with loss of tolerance after a period of abstinence. And this is the point at which the evidence of Dr. Chapman and the fresh evidence of Dr. Langford is particularly relevant. If I can ask my lord, my lady, it's set out in the judgment, but I'll just show you where you find it in the bundle. It's the supplementary bundle, page 78, where you'll find Dr. Chapman's evidence. He was the pathologist, and he was asked some questions about loss of tolerance, and you'll see the answer that he gave in an email on the 7th of August, which is on page 78. Halfway down the page, I've reviewed that. He said, "Thank you. I've reviewed the PRM report, the PM report, and the toxicology. It indicates significant levels of cocaine and lower levels of morphine and other medications. Tolerance to opiate drugs can be lost rapidly during abstinence, so a period in hospital could make taking the drug more dangerous once drug abuse is restarted. Tolerance to cocaine is less significant." Now, my lords, that evidence that we placed weight on before the divisional court rejected it. And so what we've since done is obtain the expert report of Dr. Langford. Can I just ask if my lords, my lady, had an opportunity to read Dr. Langford's report?
Yes. Mm-hmm.
Because if so, I don't need to take you to it. But I can give you the key passages in his report. If my lord, my lady, turn to page 249 of the bundle, his report starts at page 244, and his evidence is in two parts. First, he deals with the general risks associated with loss of tolerance, and then in the second part, he deals with specific risks to Tanya in the circumstances of her case. But if one looks at page 248, you can see the question that was asked, the general question: please comment on the existence and extent of risk of death by overdose of a person in the event they relapse into cocaine and or opioid use after a long period of abstinence. And over the page, paragraph 16, it's in bold. This loss of tolerance in an abstinent individual who has previously misused drugs places them at an increased risk of overdose should they revert back to substance misuse without making the necessary adjustments in the dose of substances they are using. This period of increased risk is greatest immediately after a period of absence and has been consistently shown to be a risk factor for death in multiple studies. And while, as you can see, those studies are quite old. They're sort of 2003, so it's not as though they're things that shouldn't have been known to the trust team at the time. Paragraph 17, again in bold, the UK Home Office report in 2005 indicated that the risk of death from drug-related causes was greatest immediately following release. And over the page, again in bold, presents a major hazard in the first few weeks after release. And the same at paragraph 18. And then at paragraph 20, he points out further additional risk factors. They include a concurrent mental illness combined with a lack of social support, relationship dissatisfaction, feelings of hopelessness, as well as having a previous medical history involving hospital admissions with previous overdoses, all of which, of course, apply Tanya's case. And paragraph 21 points out that individuals may not be aware that they have a loss of tolerance and fail to realise how susceptible they've become. Paragraph 23, the major drug associated with an increased risk of fatal and non-fatal overdose is heroin. But cocaine also plays a significant role in many of these unfortunate cases. And what's significant about Dr. Langford's evidence, in fact, is that Dr. Chapman had said that cocaine was of less relevance, but in fact, Dr. Langford's evidence is that, in fact, the cocaine abuse was significant. And then over the page 252, Dr. Langford was asked the question, please comment on the risk of such risks in Tanya's case in the event that she relapsed into cocaine and or opiate and alcohol use. Paragraph 24, he says she would have lost tolerance to the drugs she'd previously been taking. He says previous heavy drug misuse is an additional risk factor for an early drug-related death following discharge. My lord, one of the reasons I took you to the entry on the 3rd of December 2017 is to show that she did have a history of heavy drug use to the extent that she'd had to be hospitalised. Paragraph 26, the co-presence of ongoing mental health issues is an additional risk. And my lords, the other conclusions, again, they're highlighted. Paragraph 34 at page 255, first line, death following cocaine use is not uncommon. And then I think, my lords, I'll leave you to read those conclusions. Just take you to paragraph 258, paragraph 42. Just that my lords read that, and then the bullet point under the summary, again, it's highlighted in bold. It says, from the details outlined in the literature and from review of the clinical details, she was at a high risk of having a drug-related death. And my lords, we say that those are factors that the trust, any competent psychiatrist would have known or should have known about the risks associated with loss of tolerance to opiates, particularly with a patient who has a diagnosis of substance misuse and repeated relapses into drug use. And one would have expected there to have been some consideration of those factors at the time of Tanya's discharge, and at no point, whether it was on the 25th of June or on the 2nd of July, was any consideration given to them. My lords, then we turn to the steps that were taken following her second AWOL, and this is set out in the judgment from paragraph 22. And my lords, the key point that we make about this period, firstly, is that it was evident that the hospital were concerned about Tanya's drug taking, because if we go back to the running notes, we can see page 46 in the supplementary bundle. That she was she left the unit on the 3rd of July, and the hospital tried to call her, and then if you see the top of page 46, third line, Tanya has been recently discharged from Section 3 and has a risk of vulnerability to taking illicit substances and misusing alcohol. Due to this, she was circulated to the police for a welfare check. And my lords, you have a copy of the computer-aided dispatch message of the police visit to her flat at 2:19 a.m. That's at page 71. I don't need to take you to it, except to note that the police noted that the hospital would need to consider Section 135 of the Mental Health Act, and I'll come back to that in due course. And there's also a transcript of a missing persons call, which was the call made to the police from the hospital, which is at pages 67 to 71 of the supplementary bundle. Again, I'll leave my lords to read that, but on 3 occasions, the caller makes clear that the risk to Tanya is because of her drug misuse. Now, my lords, we make particular criticism of the Trust's failure to go and visit Tanya's home. So while the police went on the 4th of July, and while the Trust did try to make contact by telephone, there was no visit by Trust staff before the 11th of July, by which time Tanya had been dead for 2 days, or sorry, Tanya's body had been discovered 2 days previously. And we say that that wasn't consistent with the Trust's own internal policy. And my lords will see that is at page 163 of the bundle. And if we look at paragraph 4.2.6 on page 163, does my lords and my lady have that? If the patient does not return, it begins. The patient does not return and is away overnight. Staff should contact any other staff involved in caring for the patient in the community, i.e. the care coordinator or lead professional, or staff who consider involving the home treatment team. They can be asked to visit to see if the patient is at home, assess the patient's condition, and discuss the patient's return to the ward. It might be necessary to request a mental health act assessment if the patient is refusing to return. Now, my lords, what is curious is that according to the records, the running records, Yvonne Scott, who was the care coordinator, so she was the community social worker, was contacted on the 6th of July and notified of Tanya's absence. But her evidence is that she doesn't recall being notified until the 11th. And you'll see that on page 124 of the bundle. This is a member.
We're losing you.
Obviously, we can't explore.
Mr. Bowen, we're losing you again. So you're drawing our attention to
Page 124.
the evidence of Yvonne Scott. Yes.
She says on the 11th of July 18, I was informed by a member of staff that Mr. Morahan was AWOL. So she has no record of having been notified before then. My lords, the only point we make is that at some point between the 3rd of July and the 11th of July, one would have expected more to have been done by the Trust to have located Tanya than to have notified the police and to have made phone calls. And that somebody should have gone before they did in fact go, which is on the 11th of July. And there was no consideration given to the use of obtaining a Section 135 warrant, and I'll show you Section 135 in a moment, which would have been the means by which they could have obtained access to Tanya's home if they had visited and established that she was there. So, my lords, that's all I wanted to say about the background. In essence, what we say is that not enough was done after the second AWOL to track her down. In particular, no steps were taken to visit her home by the Trust until after her body had been discovered 2 days previously, which itself does not show particularly great communication between the Trust and the police who had found her on the 9th of July. And secondly, not enough was done after the first AWOL in light of the risks that were now evident of her relapsing, given that she had gone off on the 1st of July, travelled abroad and got drunk. So, my lords, I won't need now to address you on the facts when we come to the arguable case section, the issue 3. That's the background evidence. The decisions under challenge, I don't need to take you to. If Mr. Hoff wants to take you to them, he can, but you've got them in your list of essential reading. What I propose to do now is to take you through the relevant legal framework with my Lord's leave, and starting with the Coroners and Justice Act, which you'll find in the first volume of authorities, the blue volume. And I can deal with this, I hope, relatively swiftly. If we start at section 1 of the Coroners and Justice Act at page 67, it's the second tab in volume 1. The duty to investigate in section 1, and the duty arises in subsection 2. This subsection applies if the coroner has reason to suspect that the deceased died of violent or unnatural death, the cause of death is unknown, or the deceased died while in custody or otherwise in state detention. Now, we accept that Tanya was not in state detention within the definition of the Act, but she did die an unnatural death. My Lord, the coroner can, if you turn to page paragraph 14 at page 76, may request a suitable practitioner to make a post-mortem examination. And then, if you go back to section 4, page 69, having received the post-mortem examination, he has or she has the power to discontinue an investigation. But that power is not exercisable, see subsection 2, if the coroner has reason to suspect that the deceased died of violent or unnatural death, or died while in custody or otherwise in state detention. So there has to be an investigation.
Well, I think, Mr. Bowen, just pause for a moment. This is uncontroversial and it's common ground, so I don't think we need to go through.
It is, my Lord.
I think perhaps the statutory provision we should look at is the statutory provision that provides for the different outcome in the event that it's an Article 2
That's the
inquest.
next one. That's the next provision, section 5, which is on page 769.
Yes. So section 5.2, which again is familiar.
It is. And so, my Lord, the difference between section 5.1 and section 5.2 is the difference that was identified by the House of Lords in Middleton between an Article 2 compliant inquest and a Jameson inquest. So in an ordinary inquest, the purpose of the investigation is limited to identifying the factors in subsection 1, but in a Article 2 inquest, they must include the factors set out in subsection 2. My Lords, if I just give my Lords the relevant paragraphs and sections, and then my Lords can deal with them, read them later. But section 6 is the duty to hold an inquest as part of an investigation. Section 7 deals with juries. Section 10, the determination is to be made. Section 48 is the definition, including the definition of state detention. And we accept it doesn't include voluntary patients. And then Schedule 5 of paragraph 7 is the coroner's power to make reports to prevent future deaths. My Lords, I mentioned the Mental Health Act, Section 135, and the relevant provisions of the Mental Health Act are set out at tab 3. I only need to draw your attention to a couple of provisions. Section 5, which is at page 112, and subsection 2 and subsection 4 are the so-called emergency powers of detention, and they are the powers that can be exercised in relation to a voluntary patient if the hospital decides, in the case of section 5.2, a single medical practitioner. In the case of subsection 4, a nurse can detain a voluntary patient under sections 5 or 2 or subsection 5.4. And then section 135, my lords, you'll find at page 167. Again, I don't need to take you through it, but it is the power to apply to a magistrate for a warrant in relation to a patient who is at risk. And we accept that in relation to Tanya, now that she was no longer a detained patient, then the only powers that would have been available in relation to her would have been to obtain a warrant under section 135 if she hadn't responded to visits from the trust, had they been made. And then, my lords, at section 47 of the National Health Service Community Care Act is the duty to assess for section 117 care. I'm sorry, I should have showed you section 117. That's the duty to provide aftercare. It may be that that's very familiar to my lords and my lady, section 117 of the Mental Health Act, which is at page 165. That's the duty to provide aftercare to patients who have been detained. And section 47 of the National Health Service and Community Care Act, which is tab 4, page 185, is the duty on local authorities to carry out an assessment for the purposes of a person's needs for services under section 117. And in relation to that duty, we draw attention to the guidance, which you'll find at tab 5 of the same volume, at page 189. The provision that makes clear that the duty to provide aftercare begins as soon as the patient leaves hospital. Sorry, the duty to provide aftercare begins when the patient leaves hospital. The planning of aftercare needs to start as soon as the patient is admitted to hospital. And my lords, I'll show you in due course what Lady Hale had to say about a failure to carry out care planning in the Raybone case. My lords, the last matter, just to draw to your attention, I don't think I need to show it to you now, but is the Lord Chancellor's exceptional case funding guidance, which is at tab 11 of the supplementary bundle of authorities. Just for your note. And that explains how there are some categories of case in which legal aid must be provided, including where Article 2, the enhanced duty, is engaged. And you'll find that at page 271 of the supplementary bundle of authorities. My lords, against that brief outline of the legal framework, I can turn to the propositions of law that we developed in our skeleton argument. And I can do this by referring you to the relevant paragraph in my skeleton argument. So if we start at paragraph 22 of the skeleton argument. My lords, my lady, the matter sets out at paragraph 23 as to when a substantive duties arise. But it might be helpful if we looked at what the divisional court said at paragraph 29 to 31 for a summary. So it's page 72 of the core bundle, where the divisional court sets out paragraph 29, the Article 2, paragraph 30, the negative duty under subsection 1, the positive duty to protect life, which includes both the framework duty and the positive operational duty. None of that is, of course, contentious. And then he said this, Justice Popplewell said this: there is an investigative duty to inquire into and explain the circumstances of a death, as I explained below, there are two different investigative duties which have a different scope and different juridical basis. One is a substantive duty to investigate every death as an aspect of the framework duty. The other is a procedural obligation which arises only in some cases and is parasitic on the possibility of a breach by a state agent of one of the substantive operational systems duties. When the latter arises, it's a duty of enhanced investigation to initiate an effective public investigation by an independent official body. This is the enhanced investigative duty. Now, my lords, there's no mention there of the second of the investigative duties, which I'll come to in just a moment, which is the medical negligence type investigation, which I'll address you on in a moment. And ordinarily, when the courts have addressed this question in the past, they've identified two investigative duties. One, the enhanced investigative duty, which applies in that narrow range of cases where there's an arguable breach, and one that applies in a much wider range of circumstances. What has been given less attention, it's fair to say, is the duty that Lord Justice Popplewell identifies in the third line, the substantive duty to investigate every death as an aspect of the framework duty. And I think if I just make clear what my submission is now, this is derived, that sentence, or that part of the sentence, is derived from something that Lord Phillips said at paragraph 70 of Smith, when Lord Phillips indicated that there were effectively two stages to any investigation. A first stage, which involved a duty to investigate every death, and secondly, a duty, if an arguable breach was then shown, to investigate deaths, the enhanced investigative duty. And what we say is that duty, the duty to investigate every death, as identified in paragraph 70, subsection 2 of Smith, applies in non-automatic cases. And it's our case that it has no part to play in an automatic case. And I recognise in making that submission that I'll need to persuade you that what my lord, the Lord Chief Justice, said in Tyrrell and Maguire was not right. And that because my lord indicated that first step applied even in automatic cases, i.e. those involving detainees. So putting that out there, my lords, I will just rewind and say that the two investigative duties that are specifically recognised by Strasbourg are most conveniently set out by Lady Justice Smith in her judgment in Humberstone, which I'm sure will be familiar, but if I could just take you to what the court said there. It's Humberstone is volume 1 at tab 18, so that's the blue volume. And if my lords turn to page 459, this was a case involving a challenge to a refusal of legal aid. And paragraph 52, Lady Justice Smith set out two different duties that are recognised by the Strasbourg Court. If you just pick it up just above G, and then finish just in the last sentence. If I could just ask my lord, my lady, to read to the end of that paragraph on that page. And my lords, the paragraph 65, paragraph 67, she returns to that theme, but I don't need to take you to it. The fact is that there are these two duties, one that applies in a wide range of circumstances where there may be some state involvement, but there's unlikely to be any breach of an operational duty, and one that applies in a narrower range of circumstances where there needs to be an arguable breach of a substantive operational or systems duty. And the first duty, the wider one, was identified in a case called Vaux in France. I'll give you the reference because it's referred to in subsequent case law, which is it's at volume 3, tab 62. It's paragraph 89, page 2208 of the bundle. But I don't need to take you to it because I can show you the same passage in the most recent decision of the Grand Court in Lopez de Souza. If I could ask you to turn that up to volume 3, that's the white volume, at tab 56. This is a judgment I'll be coming back to in the context of the operational duty, but just at this stage to identify these two separate duties. 4.
Could we have the reference again, please?
In France, type investigation. The court has interpreted the. Sorry, my lord. 1864.
Thank you. It's just you broke up then.
Page at the top.
And perhaps we could have the paragraph number of the judgments. That's always the easiest way in.
214.
Thank you. Yes.
So if I could ask my lord, my lady to read paragraph 214.
Mm-hmm.
And then over the page to read paragraph 220. So the key distinction in a Vaux in France type investigation is that there's no duty on the motion to instigate an investigation, and it can therefore be discharged by the availability of suitable civil proceedings. And what that means is that in a Vaux in France type case, a Jameson type inquest is sufficient, and it's not necessary to have a Section 5.2 Middleton inquest. By the same token, of the family as there is in the other kind of enhanced investigation, which I'll show you in a moment. And therefore there's no requirement for legal aid. I gather I might have just broken up there.
We caught it.
For legal aid.
Don't worry. We caught that, but you did break up a little.
So was the key then between that kind of investigation and the enhanced investigation, the inarguable breach of an operational or systems duty for the enhanced duty, but where it's triggered, we go to paragraph 69 of the Divisional Court's judgment. You'll see there set out paragraph 64 of the Supreme Court's judgment in Smith. That's page 88 of the core bundle. The duties that Lady just went to in Humberston. This is the enhanced duty, and it's introduced to paragraph 68 and 69 of the Divisional Court's judgment. And then over the page is set out paragraph 64 of Lord Phillips' judgment in Smith, which sets out the key features of the enhanced investigative duty. And the most important ones for our purposes are the first line, procedural obligation requires a state of its own motion to carry out an investigation. So that's the first key distinction between the wider investigative duty and the enhanced investigative duty, that the state must of its own motion. It's not enough if the individual can trigger civil proceedings, for example. It's got to, of its own motion, carry it out. There must be a sufficient element of public scrutiny.
Well, again, Mr. Bowen, I don't mean to, I don't want to interrupt you too much, but this is, I mean, this, as Lord Phillips says, comes from Middleton through the Strasbourg jurisprudence, which is mostly Jordan, if I remember correctly, paragraph 105, and it really is fairly, it's fairly basic stuff in the context of the case we're dealing with today.
But I just wanted to make that the key distinction being the requirement that it be of the state's own motion.
Yes.
As opposed to civil legal proceedings being sufficient, and the requirement that the family be able to play an appropriate part, which has been interpreted since then as a requirement that they have legal aid, which doesn't apply. And it's these sorts of cases that through Middleton, following the codification of Middleton by the Coroners of Justice Act 2009, require a Section 5.2 inquest, and that's what we're concerned with. My lords, there is this third duty that I showed you being referred to in paragraph 31, subsection 3 of the Divisional Court's judgment. And if I may just take you to that, because it's not one that you'll find in the Strasbourg jurisprudence, but you'll find it in, firstly, Lord Phillips's judgment in Smith. And that's volume 2, that's the grey bundle. At tab 40, paragraph 70. And it's page 1180. Again, rather than me reading it out, my lords, if you just read paragraph 70. And then paragraph 71 down to D.
I'm afraid I've not caught up with you, and I'm sure it's my fault. Which tab are we in?
40.
At paragraph...
We're tab 40, paragraph 70.
70.
70, and it's internal, the page number, the bundle page number is 1180.
Thank you.
My Lord, the Lord Chief Justice will be very familiar with this passage.
I am, but I had turned to the judgment of the Court of Appeal, which was my mistake, so forgive me. Paragraph 70, page 1180. I have it.
1180, my Lord, yes.
Yep.
And you'll see what Lord Phillips says there is that any effective system of investigation has to have two stages. One, a stage where any potential breach is identified, which must apply in a wide range of situations, and another one where, having identified an arguable or possible breach, there is then an investigation, a duty to carry out a more intensive investigation. And he indicates that the first stage is discharged domestically through the process of registering under the Births and Deaths Registration Act, and it's that first duty, the wider duty to investigate all deaths that then becomes interpreted in Tyrrell and Maguire and then in Morahan as applying even in cases such as a prisoner death. And I'll make a submission now that you have this passage open. It's our submission that Lord Phillips at paragraph 70 is only referring to non-automatic cases. So Smith was a case involving the death of a military serviceman in circumstances where the the Supreme Court decided that there was no automatic duty of investigation. And the passage of paragraph 70 is only concerned with non-automatic cases. And you can see that because if you then turn to paragraph 84 of Lord Phillips's judgment, he says, that's page 1184, he says, the obligation to hold an Article 2 investigation is triggered by circumstances that give ground for suspicion that the state may have breached a substantive obligation imposed by Article 2. That in its turn raises the question of the scope of the substantive obligations that the state owes in relation to its armed forces, which I've raised above. Whatever the scope of those obligations, and this is a critical sentence, I do not consider that the death of a soldier on active service of itself raises a presumption that there's been a breach of those obligations. So he's contrasting this, the case of a serviceman on active service, with those cases which I'll be showing you where there is a presumption of breach. And for those reasons, you'll see, he said, I reject the submission that the death of a serviceman automatically gives rise to an obligation to hold an Article 2 investigation. So, my lords, it's important when I come to Tyrrell and Maguire to make clear, we submit that in an automatic case, there is not this staged approach. In an automatic case, there is only one duty, the enhanced investigative duty, that is triggered automatically. And if this is a case where the automatic duty applies, then the question of whether there's an arguable breach never falls to be considered. Now, my lords, we're at paragraph 26 of my skeleton argument, and it's our submission that certainly in novel cases where the extent of the operational duty is unclear, or the operation of the automatic duty is unclear, it's necessary for the court to approach the question of whether there's an enhanced investigative duty by two steps. The first one is to identify whether there's a duty of care in principle, an operational duty in principle. And the second is to then determine whether there's an arguable breach. And in determining whether there's an arguable breach, that itself falls into two steps or stages. The first one is if it's an automatic case, then the arguable breach is presumed. And in a non-automatic case, it's necessary for there to be evidence of an arguable breach. So the first step, this is issue 1, is an operational duty owed in principle. And this is paragraph 28 of my skeleton argument. And it's our submission, as set out in our skeleton argument, that Tanya's situation should not be considered any different from Melanie Raybone's in the Raybone case, and the fact that her death was caused by a drugs overdose rather than suicide is nothing to the point, at least for the purposes of establishing whether there's an operational duty. My lords, paragraphs 29 to 31, I don't need to take you through. We're not concerned here with the systems duty, we're concerned here with the operational duty. But I do need to just develop the submission why it's necessary to determine whether an operational duty is owed in principle, because it was a submission we made to the divisional court, and the divisional court rejected it, and the coroner has also argued that it's not necessary to have these two stages or steps. And what we say is that where there's a novel duty involved, then it is necessary. The reason why it's necessary is because while the Strasbourg court has identified in Osman the three criteria of when a operational duty arises. Is there a real and immediate risk of harm? Does the state know or have constructive knowledge of that did they fail to do all that is reasonably available to them, take the steps that were reasonably available to them to avoid that. There are cases where, notwithstanding those steps might otherwise be met, the court does not recognise an operational duty. Effectively, it excludes liability under the operational duty on what can only be considered are public policy grounds. So the examples are the Powell-type medical negligence cases, which I'm going to be looking at in a bit more detail. In suicide cases, there's no operational duty to protect individuals who are not detained, even though there's a duty to protect those who are detained or who are voluntary patients. And I'll show you paragraph 100 of Raybone for that. Another example, my lords, the Osman case concerned the duty of the police to protect the third party who was at risk from an individual who was at risk of being murdered by a third party. But in the Mitchell and Glasgow City Council case, that's at volume 2, tab 31, the Supreme Court rejected a claim when it was brought against the local housing trust because there was no duty in principle owed in those circumstances. It's only Lord Rogers' speech you need to look at, paragraph 68 to 69 and 70 of his speech. Another example, my lords, is the situation with which the Supreme Court were concerned in Smith. There's no operational duty owed to a soldier who is anything other than a conscript or very newly conscripted or very newly drafted. So on policy grounds, essentially, the court does not accept that there's an operational duty owed to trained soldiers who are killed in action. And the explanation for that can be found in the Strasbourg case of Stojanovi in Bulgaria, where the Strasbourg court was concerned with a soldier who had died on a parachute exercise, and the Strasbourg court had held that the risk was one that was not an exceptional risk. Essentially, a trained soldier assumed certain risks, and therefore there's no operational duty. And well, these are all examples of where, even though the operational duty is satisfied on the evidence, there is no operational duty because it's excluded on policy grounds. Now, in any case which comes before the courts where there's an argument that there should be an enhanced investigation, obviously, if it's one of those cases where there's no operational duty at all, it will be necessary to decide that point first before even looking at the underlying evidence, because even if there's an arguable breach, there's no enhanced investigation. So that's the first situation in which one would need to approach things in these steps. The second is in cases like this one. So where the question is there an operational duty, and if so, it's a situation in which there's an automatic enhanced investigative duty. The question of whether on the facts there's an question on the facts whether there's an arguable breach is irrelevant. Because if there's an operational duty owed in principle, then automatically there must be an enhanced investigation. So that's another situation in which it's necessary to break the question down into those steps. Is there a duty in principle? If so, is it an automatic case or is it a non-automatic case? And while it may be necessary in other cases, if it's a civil action seeking damages for a breach of Article 2, if there's no duty of care owed in principle, then the court won't go any further. And indeed, that's exactly the approach that the court, that the Supreme Court took in Raybone. So in Raybone, the court considered two questions. Well, they considered a number of questions, but they considered two questions principally. This is paragraph 14 of their judgment, which I'll be showing you in a moment. But at paragraph 14, they isolated the issues as, firstly, was a duty owed in principle? And secondly, was there a duty owed on the facts, and was it breached on the facts? And my lords, the same approach is taken in Fernandez, the Grand Court decision, which effectively endorses Raybone, the paragraphs 124 to 125. So I'll take you to those in a moment. So what we say is that in those cases, establishing whether a duty is owed in principle is a question of law. It's a category exercise. Does the category of what body to which the state body belongs, which includes the powers that it has, which was relevant in the Mitchell case, owe a duty to the category of persons to which the deceased belonged? And a distinction is there made between detainees and other categories of individual, having regard to the category of risk to which the deceased was exposed, was it an exceptional or ordinary risk, and having regard to the category of acts or omissions that caused or contributed to the death. And it's those category factors that are embodied, we say, in the threefold Raybone criteria of assumption of responsibility and exceptional risk and vulnerability. And my lords, we say there's a parallel here with the approach taken at common law in negligence, where occasionally the courts, in novel cases, will distinguish between a so-called notional duty, that's what's called in Clark and Linsell, I'm going to show you in just a moment, and a factual duty. And if I could just ask my lords to turn up the supplementary bundle of authorities, where you'll find Clark and Linsell at tab 12 of that bundle. And it's 7-08 on page 281. If I could just ask you to read that paragraph, which finishes just before, as Lord Brown Wilkinson has said. And then when you've read that, if you turn over the page to 7-09, under the heading factual duty, just that first sentence. So essentially, the same analysis may be required in a case whether it's determining the existence of an enhanced investigative duty or whether it's determining liability for a substantive breach at an early stage, to determine as a question of law whether an operational duty is capable of being owed or is in principle owed. But it doesn't happen, it won't be necessary in every case. And for the same reason, it's not required in negligence cases. And my lords, I'll just refer you to what the current President, Lord Reed, said in the Robinson case on this point, which you'll find in the supplementary bundle of authorities, the same bundle I just showed you at tab 6, where in the context of the question of whether it was necessary to reconsider the liability of the police for their acts and omissions, the President drew a distinction between so-called novel cases and those cases where it's apparent from, by reference to previous case law, that a case falls within existing categories where a duty is owed. So it's paragraph 27 of page 104. And it's just that first 3 lines that I draw to my Lord's attention at this point. All we're doing is isolating, in those cases where it's necessary, whether a duty is owed in principle, because, as in this case, if it's owed in principle, whether a duty was owed on the facts or was breached on the facts is completely irrelevant. So, my lords, against that background, I can turn to paragraph 32 of my skeleton, where we look at that category of case which has caused perhaps the most difficulty for the courts in deciding whether a duty of care, an operational duty is owed in principle. The healthcare cases, which started with the case of Powell back in 2000. And my lords, our submission is this, and this is slightly not quite how it's put in our skeleton, so I'll just be clear what it is that we're saying. There are some circumstances in which the court, as a matter of principle, will recognise an Osmond duty to provide life-saving medical treatment to protect against the consequences of both self-inflicted harm and naturally occurring illness or disability. But the court draws a distinction between three groups. On the one hand, the general population, to whom there is, in general, no operational duty. The second category are what I will be calling detainees, with a capital D, and that encompasses not only those who are actually detained, but those who the court has treated as falling into this category. So that includes military conscripts, and it includes voluntary psychiatric patients. But I'm going to call them detainees for ease. And then there's a third category of particularly vulnerable persons under the care of the state. And my lords, I'm going to show you it in a moment, but this distinction is one that is isolated in the Grand Chamber decision of Lopez de Souza at paragraph 163. And I'm just going to develop, in relation to each of those groups, the nature of the operational duty that's owed before making the submission as to which group Tanya should be assimilated to. In relation to the general population, my Lord, the Lord Chief Justice will be very familiar with the case of Lopez de Souza. This is a group that were identified first in the Powell case. I don't need to take you to Powell because I'm going to show you a passage in Lopez de Souza which contains the relevant paragraph of Powell. So if I could ask you to turn up the Lopez de Souza case, which is in volume 3, and it's tab 56. But in a nutshell, my lords, there is no operational duty owed to the general population to protect them from the consequences of naturally occurring disease or disability, or from suicide. And one sees the volume. It starts at page 1853 of tab 56. If I could ask you to start your reading at 1853, which is paragraph 163. If you perhaps read paragraph 162. So one can see from paragraph 163 that what follows does not apply to those who are detained and those who are particularly vulnerable persons under the care of the state. And then if you go over the page, paragraph 165, don't need to read 164. The court made the point that the right to health is not as such guaranteed. Paragraph 166, in the particular context of healthcare, the court has interpreted the substantive positive obligation of the state as requiring the latter to make regulations compelling hospitals for the private or public to adopt appropriate measures for the protection of patients' lives. So that's the framework duty. However, it has not excluded the possibility that the acts and omissions of the authorities in the context of public health policies may, in certain circumstances, engage the contracting party's responsibility under the substantive limit of Article 2. Interpreted, it has not excluded the possibility that there may be an operational duty in some cases. Then in paragraph 168, it sets out the passage from Powell, and you can see footnoted at footnote 38, the reference to Powell. Case law on medical negligence. In cases where allegations of medical negligence were made in the context of the treatment of a patient, the court has consistently emphasised where a contracting state has made adequate provision for securing high professional standards among health professionals and the protection of the lives of patients, matters such as an error of judgment on the part of a health professional or negligent coordination among health professionals in the treatment of a particular patient are not sufficient of themselves to call a contracting state to account. From the point of view of its positive obligation under Article 2. So, short summary, medical negligence does not lead to a breach of the operational duty. And then, if you go over the page to paragraphs 173 to 175, the case law on denial of healthcare, the court has further held that an issue may arise under Article 2 where it's shown that the authorities of the contracting state have put an individual's life at risk with the denial of healthcare, which they've undertaken to make available to the population generally. And it gives some examples in paragraph 174. But the general position is set out in paragraph 175, and this is the other key aspect of the position as regards the general population. In this connection, the court reiterates that issues such as the allocation of public funds in the area of healthcare are not a matter on which the court should take a stand, and it's for the competent authorities of the contracting state to consider and decide how their limited resources should be allocated. So the court will not get involved in resource allocation decisions. So that is the rationale for why the court will not find a breach of Article 2 in the case of the general population, the operational duty, in the case of the general population, in respect of refusals to provide life-saving healthcare. And then if you pick it up again at paragraph 186, or 185, having regard to its case law summarised above, the court considers that the approach adopted hitherto should be clarified. And in this regard, the court reaffirms that in the context of alleged medical negligence, the state's substantive positive obligations relating to medical treatment are limited to a duty to regulate, that is to say, a duty to put in place an effective regulatory framework compelling hospitals, whether private or public, to adopt appropriate measures for the protection of patients' lives. Now, my lords, they go on to identify two exceptional circumstances where an operational duty can be found, but we're not relying on either of those, so I don't need to show you those passages, but you'll find them at paragraphs 187 and then paragraphs 190 to 196, and my Lord, the Lord Chief Justice, will be very familiar with those passages as they featured heavily in the Maguire case. But the starting point is there is no operational duty to provide treatment, even for life-saving medical treatment, and negligent medical treatment will not engage the state's duties under Article 2, at least in the context of its operational duties. And my lords, there are many domestic cases which have been concerned with the Powell type of case, where it's been held that it's a Powell type case, and therefore there's no enhanced investigation. Cases like Humberston, Parkinson, Maguire I'll come back to, but those are Powell-type cases. And my lords, as I said, I made the submission earlier, and I just make it good now, that similarly, there's no general operational duty on the state to protect members of the general population from self-harm or suicide. Now, although Lopez de Souza is not concerned with self-harm or suicide, this was a point that was made by Baroness Hale in the case of Raybone. I'm going to be showing you that passage in a moment, but it comes, or it's endorsed by a Strasbourg case, which I'll just show you. It's called Haas in Switzerland, which is at volume 3, tab 52 of the main bundle, so that's the white volume, tab 52, starting at page 1696. And I only need to show you, it's an assisted suicide case, I only need to show you what the court said at paragraph 54, which starts at page 1711. Does my lord, my lady have that passage?
Mm-hmm.
In short, there's no duty, there's no protective duty in relation to somebody who is suicidal, even if the Osmond criteria are otherwise satisfied, if the individual's decision has been freely made in full knowledge of the facts. And I'll show you what Baroness Hale said on this subject in a moment. So in terms of that group, general population, there's no duty to provide health care. Medical negligence does not trigger a duty, does not involve a breach of Article 2 in its substantive aspect. There's no duty to protect against suicide or self-harm. So for the second group, that's detainees, and as I've explained, that includes military conscripts and, since the Rayburn and the Fernandez de Oliveira case, voluntary psychiatric patients. But they're all within this group. There is a general population. There is a general operational duty to provide healthcare in respect of life-saving risks to life. And there's also an operational duty to take steps to prevent a person from taking their own life. And 2 points to be made about this category. The first one is that if medical negligence is involved in the context of the provision of life-saving medical treatment that the state is under a duty to provide, there can be a breach of Article 2, by contrast with the position for the general population. And secondly, the state cannot rely on an absence of resources to avoid the duty. So those are two matters that distinguish detainees from the general population. And of course that also has consequences in terms of the enhanced investigative duties that are owed. What I propose to do, my lords, is just take you through the case law, firstly dealing with healthcare cases, then I'm going to show you the suicide self-harm cases, then I'm just going to deal with natural causes cases, because it's my submission that it's the natural causes cases that have caused the most difficulty, or dealing with natural cause cases that have caused most difficulty in this case. My lords, cats in Ukraine is the first case. And again, my Lord Chief Justice will be very familiar with this case. I do need to take you to it, if only to distinguish a passage in it from the next case that I'm going to take you to. It's volume 3, so it's the white volume. And it's tab 54. And if you start at paragraph 101, you can see that this was a case where a prisoner complained that, the family of a prisoner complained that the deceased had died in detention because she had not received timely and adequate medical aid. So it was that was the complaint. And then if we turn to paragraph 104, this is the critical paragraph. Persons in custody are in a particularly vulnerable position, and the authorities are under an obligation to account for their treatment. Having held that the Convention requires the state to protect the health and physical well-being of persons deprived of their liberty, for example, by providing them with the requisite medical assistance, the court considers that where a detainee dies as a result of a health problem, the state must offer an explanation as to this cause of death and the treatment administered to the person concerned prior to his or her death. As a general rule, the mere fact that an individual dies in suspicious circumstances while in custody should raise an issue as to whether the state has complied with its obligation to protect that person's right to life. Now, my Lord, what we see conflated in that paragraph are three things. One is the operational duty to provide medical treatment, the requisite medical assistance to persons who are at risk of death as a result of a naturally occurring disease. The second is that there is a presumption. The state must offer an explanation as to the cause of death and the treatment administered to the person concerned prior to his or her death. So the duty is on the state, and I'll show you in another passage in a moment, to discharge the obligation of showing that the death occurred in circumstances where there was no breach. And then the third thing, as a general rule, the mere fact that an individual dies in suspicious circumstances while in custody, the Lord Chief Justice in the Tyrrell case interpreted that sentence as meaning that only if it can be shown at some initial stage that the death has occurred in suspicious circumstances, i.e. there's an arguable breach, that there is a duty to conduct an enhanced investigation. Now, I'm going to have to come back to this passage because at the moment we're only concerned with the operational duty, but I'm just pointing out now that the Lord Chief Justice's interpretation of that passage on the submission when I come to the automatic duty. First point to make is that from the point of view of a person in custody, the lack of medical assistance does engage Article 2 in a way that it doesn't for the general population. And you can see paragraph 107, I don't need to take you to 107 and then 111 to 112, that a breach was found because of a failure to provide adequate medical treatment. Now, I will need to come back to CATS in the context of the of the automatic duty of investigation in a moment, but I'm just dealing with, at the moment, with the operational duty. Could I ask my lords to put that to one side and to turn up in the same volume the case of Macarazzi in Georgia, which you'll find at tab 57 of that volume. And the first paragraph that is relevant is at paragraph 71, which is page 1937. And you'll see a similar statement. The last four lines of that paragraph, the obligation to protect the life of individuals in custody also implies an obligation for the authorities to provide them with the medical care necessary to safeguard their lives. And then paragraph 72, that furthermore the authorities must account for the treatment of persons deprived of their liberty. The sharp deterioration in a person's state of health in detention facilities inevitably raises serious doubts as to the adequacy of medical treatment. And then this, thus, where a detainee dies as a result of a health problem, the state must offer a reasonable explanation as to the cause of death and the treatment administered to the person concerned prior to his or her death. My lord, I just emphasise now that in CATS, the phrase used was when a person dies in suspicious circumstances. The phrase used here is when a person dies as a result of a health problem. And we respectfully submit when we come to the automatic duty, that shows that there isn't in fact a requirement to show an arguable breach before the enhanced investigation is triggered. But I'm only making that submission now just to foreshadow what I'll be submitting when I come to the automatic investigation cases. I made the submission earlier that resources were not a matter that could be taken into account when the state is discharging its duty to provide healthcare to detainees. One gets that at paragraph 87. That's at page 1943. Sorry, paragraph 90, I do beg your pardon. I'm going to be coming back to this case as well in the context of the enhanced duty of investigation.
Will
I
you
just
be?
want to show you.
Forgive me, Mr.
Sorry,
Owen. We're hopping around rather a lot, and you keep telling us you're coming back to cases.
I'm
Are we
sorry,
come-
at
are
the
we-
moment I'm only dealing with the operational duty owed to detainees, and I'm going to have to come back when I deal with the enhanced investigation duties to some of the same paragraphs because they're conflated in the same paragraphs.
All right. Can I just put down
to make good.
Sorry, just put down a marker. Will you be taking us to Silmani and France?
I won't. I wasn't trying to, my lord, but we can.
Well, the only reason
We can.
the only reason I wonder whether it might be something worth having a look at is that paragraph 104 of CATS, which is in fact 2 paragraphs. It's not 1 paragraph. The first proposition that the Strasbourg court identified is footnoted in one way, but the second proposition is footnoted by reference to Silmani and France. And so it might, I just make an observation that it might be worth having in mind what Silmani was about before taking the observation of the court possibly out of context. But take your own course. But I should say I'm finding it quite difficult myself to follow quite where some of these submissions are taking us. So at the moment, just to fix it, it's my fault, I'm sure. You're seeking to establish that somebody detained by the state is entitled to proper medical treatment, and so it's to make good the proposition that I think we've seen in Lopez de Souza, for example, that the general Powell approach is different or qualified, whatever word one wants to use, when we're dealing with people in custody, and that might include conscripted soldiers, and it might include, or does include, voluntary patients in connection with the risk of suicide. So have I understood? Yes. That's where we are.
Well, that's absolutely right, my lord. And I was just going to take you to the passage in paragraph 90 of Macarazzi, which is 1944, just to make it the proposition that lack of resources is not a reason for failing to comply with the duty. So
yeah.
The last 4 lines of paragraph 90.
Is that's not an issue in our case, though, is it?
No, my lord. I'm just drawing the distinction between the two duties at the moment.
Yeah.
Now, my lord, what we didn't do in the divisional court was show the court the case law, the Strasbourg court, in relation to the duty to provide healthcare for prisoners and detainees under Article 3, and the same duty arises to provide treatment, including adequate medical treatment, under Article 3. I'm going to give my lords the reference. I won't take you to it. It's a case called Blokhin and Russia, Blokhin and Russia, which is in the supplementary volume, tab 8. And the key point to note, and because it's not an issue here, I don't need to take you to it, but the key point to note in Blokhin and Russia is that the court analyses the concept of adequate medical treatment by reference to factors which clearly engage issues of medical negligence. So I'll give you the key passages. It's paragraphs 120, 136 to 138, 146, and 148. So, my lords, the point is, first, detainees are treated differently in relation to access to medical care. The second is, and this is more germane to the particular circumstances of Tanya's case, against self-inflicted harm. And I can now go to the Rayburn case. If I could ask you to turn up Rayburn, which is volume 2 of your authorities bundles, and it's at tab 37. To the members of the court, there's a helpful, if one picks it up at page 974, from paragraph 12, there's a useful summary of the nature of the duties raised by under Article 2, which I don't need to ask you, my lord and my lady, to read now. But if we pick it up at paragraph 14, where the issues are identified, I made the submission earlier that the court broke down the issue of whether there was an operational duty in principle into the question of whether there was a real immediate risk, etc. on the facts. See paragraph 14 from the first few lines. It's little Roman numeral 1 and little Roman numeral 2. And then paragraph 15, the court referred to cases including detention cases, including Edwards, which was a case where the individual was killed by a cellmate, Keenan, which was a self-inflicted death case, Slimani, the case my lord referred to, Savage, and Killing, which was one of the military conscript cases. And then paragraph 16, more recently the court has expanded the circumstances in which the duty is owed to include dangers for which in some way the state is responsible. That's not of concern. Paragraph 17, reference to Mamadov. Paragraph 18, reference to Watts. But the key passages for our purposes are, start with paragraph 20, where the court said this: the question that lies at the heart of the first issue, that's whether a duty was owed in principle, is whether the admitted casual negligence of the trust in its treatment of Melanie is to be assimilated to the Powell-Lider cases, or whether the fact that she was a psychiatric patient means that this case should be assimilated to the class of cases where an operational duty arises. Now, just pausing there, my lords, of course, the divisional court in this case accepted that it was bound by Rayburn, but the significant point of departure for our purposes is that the divisional court held that whether somebody was a voluntary patient or not was not sufficient of itself to show that they fell within a category that was protected. That each decision was to be made on the facts of each case, and that there may be some voluntary patients to whom a duty would not be owed. And so, as we go through these passages, our overarching submission is that what Rayburn makes clear and what Fernandez de Oliveira makes clear is that it is a category decision, and that once a patient is identified as falling within the category, then an operational duty is owed to them by reason of that fact alone. And what the court did in determining that question, we say in Rayburn, was identify the essential features of the cases. They were threefold. Although at paragraph 21, the court made clear that the existence of a real and immediate risk to life is a necessary but not sufficient condition for the existence of the duty. I'm just pausing there because one of the points that was made by the divisional court was that it was therefore necessary in establishing whether there was a duty of care in principle to establish on the facts that there was a real and immediate risk of death. And it's our case that that question does not need to be determined on the facts when deciding the question in principle. And indeed, that was the approach that the Strasbourg court, that the Supreme Court took in Rayburn. And Rayburn, the Supreme Court went on to identify three factors: paragraph 22, assumption of responsibility; 23, vulnerability; 24, exceptional nature of risk. Paragraph 25, they made clear that the question was one that was not susceptible to precise delineation because the operational duty was in its infancy and its boundaries were still being explored. And the last sentence of paragraph 25, it seems to me that the court has been tending to expand the categories of circumstances in which the operational duty will be found to exist. And then paragraph 26, the court came to what Lord Dyson referred to as the central question, where the lower court's right to hold the Powell case compels the conclusion that the trust owed no operational duty in the present case. And the court went on to find, by reference to those threefold criteria of assumption of responsibility and vulnerability and exceptional nature of the risk, that there was a duty in principle. If I might just ask you to go back to paragraph 24, because that is particularly relevant in this case. This is the factor of this is the exceptionality of the risk factor. The court said this: the further factor is the nature of the risk. Is it an ordinary risk of the kind that individuals in the relevant category should reasonably be expected to take, or is it an exceptional risk? Thus, in Stoy and Arby, the ECHR rejected an application made by the family of a soldier who died during a parachute exercise. At paragraphs 59 to 61, the court drew a distinction between risks which a soldier must expect as an incident of his ordinary military duties and dangerous situations of specific threat to life which arise exceptionally from risks posed by violent, unlawful acts of others or man-made or natural hazards. An operational obligation would only arise in the latter situation. So, pausing there, the Supreme Court in Rayburn went on to find that a risk of suicide was such an exceptional risk. It's our case that a death from a drugs overdose is also an exceptional risk. Why did the court reach those conclusions? Well, at paragraphs 27 to 28, they looked at the question of whether a voluntary patient was to be distinguished from an involuntary patient, which it was accepted following Savage there was a duty of care owed to. And paragraph 27, Lord Dyson said this: I accept, of course, that there are differences between detained and voluntary psychiatric patients, and there are similarities between voluntary patients who are suffering from mental illness and those who are suffering from physical illness. But the differences between the two categories of psychiatric patients should not be exaggerated. And then at paragraph 28, as regards the differences between an informal psychiatric patient and one who's detained under the Mental Health Act, these are in many ways more apparent than real. It's true that the paradigm of a detained patient is one who's locked up in a secure hospital environment, but a detained patient may be in an open hospital with freedom to come and go. By contrast, an informal patient may be treated in a secure environment in circumstances where she's suicidal, receiving medication, which may compromise her ability to make an informed choice to remain in hospital, and she would in any event be detained if she tried to leave. Informal inpatients can be detained temporarily under the holding powers given by Section 5 of the Mental Health Act to allow an application to be made for detention under Section 2 or 3. The statutory powers of detention are the means by which the hospital is able to protect the psychiatric patient from the specific risk of suicide. He then compared their position to that of children in the Z and UK case, and then in paragraph 29, he said this: although informal patients are not detained and are therefore in principle free to leave hospital at any time, their consent to remaining in hospital may only be as a result of fear that they will be detained. He then quoted a passage from Larry Gostin's book, and the quote says that patients admitted voluntarily, this is the fourth line, feel coerced into the admission. And then those factors the court felt were sufficient to mean that a voluntary patient should be equiparated to an involuntary patient rather than a voluntary patient in an ordinary NHS hospital. Then in paragraph 30, the court looked at the nature of the risk. This is the whether the risk was exceptional or ordinary, and then the court said this, fourth line: In the case of the suicide of a psychiatric patient, the likelihood is that given the patient's mental disorder, her capacity to make a rational decision to end her life will be to some degree impaired. She needs to be protected from the risk of death by these means. The present case is a tragic illustration. Melanie was admitted to hospital because she was suffering from a mental disorder and had attempted to commit suicide. The very reason she was admitted was because there was a risk she would commit suicide, from which she needed to be protected. On the other hand, the patient who undergoes surgery will have accepted the risk of death on the basis of informed consent. She may choose to avoid the risk by deciding not to go ahead with the medical treatment. Now, my lord, we say two things about that passage. The first one is that an individual who takes an overdose, a voluntary psychiatric patient who takes an overdose, and a voluntary psychiatric patient who self-harms, both of those are exceptional risks, because in relation to both of them, it can be said that their capacity to make a rational decision to engage in that behaviour is impaired by their mental disorder. And the second thing to say is that it's quite clear from that passage that the court is using Melanie Rayburn as an illustration of why voluntary psychiatric patients who take their own lives as a category or class should be protected, rather than, as the divisional court held, was looking at her individual circumstances and only looking at her individual circumstances. My lords, then paragraph 33, as I've said, the ECHR has not considered whether an operational duty exists to protect against the risk of suicide by informal psychiatric patients. But the Strasbourg jurisprudence shows that there is such a duty to protect persons from a real and immediate risk of suicide, at least where they're under the control of the state. By contrast, the European Court of Human Rights has stated that in the generality of cases involving medical negligence, there is no operational duty. So on which side of the line does an informal psychiatric patient such as Melanie fall? I'm in no doubt that the trust owed the operational duty to take reasonable steps to protect her from the real and immediate risk of suicide. Whether there was a real and immediate risk is the second issue that arises on this appeal. But if there was a real and immediate risk of suicide at that time, of which the trust was aware or ought to have been aware, then it might be the trust was under a duty to take reasonable steps to protect Melanie from it. Again, my lord, what's clear there is that the Lord Dyson was answering the question in principle: is the duty owed, whether or not there was a real and immediate risk to her life? Because he said that was the second issue. And then carrying on just after that line, she'd been admitted to hospital because she was a real suicide risk. By reason of her mental state, she was extremely vulnerable. The trust assumed responsibility for her. She was under its control. Although she was not a detained patient, it's clear that if she had insisted on leaving the hospital, the authorities could and should have exercised their powers under the Mental Health Act to prevent her from doing so. In fact, however, the judge found that if the trust had refused to allow her to leave, she would not have insisted on leaving. This demonstrates the control that the trust was exercising over Melanie. In reality, the difference between her position and that of a hypothetical detained psychiatric patient who was in circumstances similar to those of Melanie would have been one of form, not substance. Her position was far closer to that of such a hypothetical patient than to that of a patient undergoing treatment in a public hospital. These factors taken together lead me to conclude that the European Court of Human Rights would hold that the operational duty existed in this case. Well, again, my lords, while we accept that there were individual factors in Melanie's case that Lord Dyson took into account in deciding that there was a duty of care, particularly when one looks at the way in which he approached the question and Lady Hale approached the question, with whom the other members of the court agreed. What he was doing was holding that as a category, voluntary psychiatric patients are owed an operational duty in respect of certain risks, which include suicide or self-harm. And we respectfully submit that that Tanya's position is no different from Melanie's.
Mr. Byrne, can I just go back? You said in paragraph 30 that
yes,
the wording of 30 illustrate, and I'm paraphrasing, it indicated that Lord Dyson was giving suicide as an example. I think I'm paraphrasing what you said.
Yes.
From which you would invite us to extrapolate that it would include people in Tanya's position, i.e. those who die accidentally from
Yes,
an
he's
overdose.
talking about the category.
Could you show us precisely, or show me precisely, what words you are relying on when you say that?
So in the fourth line, Lord Dyson is dealing with the general. In the case of the suicide of a psychiatric patient, the likelihood is that given the patient's mental disorder, her capacity to make a rational decision to end her life will be to some degree impaired. She needs to be protected from the risk of death by those means. So that is the general. And then he says the present case is a tragic illustration of this. Melanie was admitted to the hospital because she was suffering from mental disorder, etc., etc. So he went from the general to the specific.
But isn't
respectfully submit?
Isn't the general he's talking about the risk of suicide?
Well, my lord,
the risk death by those means refers back to end her life, rational decision to end her life, suicide. It's all about suicide, isn't it?
Yes, well, it starts really with the first line, in fact, my lord, I'm sorry. As regards the voluntary psychiatric patient who is at risk of suicide and the patient suffering from a life-threatening physical illness, the nature to which these two categories of patient are exposed are different. Mm-hmm. So what Lord Dyson does is that he addresses the category and then he uses Melanie as an illustration of how the Rayburn criteria apply, or why the Rayburn criteria apply to those categories by reference to those three factors of assumption, responsibility, etc. And while there are parts of his judgment that can be read as him applying the specific facts of Melanie's case in deciding that there is a duty that's owed in principle, it's our submission that on analysis, particularly when you go back and look at the way that he separated out the two issues between the issue of whether there's a duty in principle and secondly whether there's a duty owed on the facts, what he does is he uses Melanie as an illustration of why it is that a voluntary psychiatric patient is owed an operational duty to protect them against harms which will include, we say, not only suicide and self-harm, will also include, in the light of the healthcare cases, any life-threatening risks which require medical intervention. And so the state is under a duty, as it is in relation to prisoners and other detainees, to provide life-saving treatment to individuals who are at risk of death. And as an even clearer, we say when you come to
I think we're losing you again, I'm afraid.
There's a few more bits of
we lost you for a moment, Mr. Bowen, and then there was rather a lot of clattering, is the only word I can use. So I think you better just reprise the last 90 seconds of submission.
Can you hear me now, my lord?
Perfectly, for the moment.
I'm afraid my headphones ran out of juice.
Oh dear.
So the submission I was making is that Rayburn is authority for the proposition that voluntary psychiatric patients as a class are owed the same duties as the state owes to other detainees as a class. And that in the same way as military conscripts, the court has identified them as being particularly vulnerable, and because not least they are under the care and control of the state. In the case of a voluntary psychiatric patient, because of the potential for being controlled, and because of the fact that they will have psychiatric issues which make it less likely they'll be able to have capacity to consent, etc., then as a class, psychiatric patients, voluntary psychiatric patients, are owed the same duties as a prisoner or a detained psychiatric patient. And when the divisional court said that's not the case, that they're not owed a duty as a category or class, then the court was wrong. And my lords, I think with that paragraph 34 of Lord Dyson's judgment, if you then look at paragraph 35, he went on to consider the question of whether on the facts there was a duty of care, and on the facts whether there was a breach of the duty of care. So you can see just above paragraph 35 on page 981, the second issue, was there a real immediate risk to the life of defendant on the 9th of April, which the trust knew or ought to have known. And the court he then went on to consider those questions. And again, this demonstrates, we respectfully submit, that when you're looking at the question in principle, is there a duty of care, or is there an operation of duty, it's not necessary to ask on the facts whether the individual was at a real and immediate risk of death, nor is it necessary to ask on the facts whether the state knew or ought to have known of that. The individual has died in circumstances where, if it was a real and immediate risk, there would have been an operational duty. There is an operational duty in principle. And once that's been established, then one goes on to consider the questions of whether there is an operational duty on the facts and whether there's a breach on the facts. And that's precisely what Lord Dyson did in the following paragraphs. I don't need to take you through them, but he carries on to paragraph 43 and concluded that on the facts, Melanie Raybone had been at a real immediate risk of death. On the facts, the trust knew or ought to have known about it, and that on the facts, they failed to take steps that were reasonably available to them. And then Baroness Hale, one turns forward to page 1000 in the bundle, at paragraph 105 to 107, we adopt what she says at paragraph 105 and 106. I don't ask my lords or my lady to read it now, but we pick it up at paragraph 107 just to support the submission I've just made, that the question of whether there's a duty in principle is separate from the question whether there's a real and immediate risk of death on facts, where she said this, however, it does not follow that because the operational duty was engaged, we would say, in principle, it has necessarily been broken. There is first the question of whether the risk is sufficiently real and immediate to require consideration of what might be done to prevent it. And she agreed with Lord Dyson on that point. Now, my lords, I mentioned that I would take you to what Baroness Hale said about the risks, the duty owed in relation to risks of self-harm and suicide owed to the general public. That was at paragraph 100. If you just go back a couple of pages to page 998, last 5 lines. I showed you a Haas in Switzerland. This reinforces the point that autonomous individuals have a right to take their own lives if that's what they truly want. If a person announces their intention of travelling to Switzerland to be assisted to commit suicide, this is not by itself sufficient to impose an obligation on Article 2 to take steps to prevent it. So that's just to, again, draw the distinction between the general population and the duty owed, and those groups that are particularly vulnerable under the care of the state, including voluntary psychiatric patients. So, my lords, that's Raybone, and I see we're now just coming up to 1 o'clock. I was going to take you to Fernandez de Oliveira, but I can do that immediately after the lunch and adjournment. If
that sounds like a good plan. So we will rise now and we will reconvene at 2 o'clock. Thank you.
Thank you, my lords. Thank you, my lady.
All right.